Kalau nanti aku dekat sama dia gitu. Ini kalau ganti hal itu ini kan kita apa tuh ya? Ada oh mari itulah. Oh, pasal naik. Hari awal ni naik, sama hari dua dan sudah naik.
Kita level siapa?
Level na. So, kawan mana kau tengah? Jadi nak ni lagi tu. Anda, isu ya. Ini insan, ini mana ini? Itu dia ada mana? Ada. Awalnya ni, awalnya.
Ini latest tweet.
Ada bukan lontar kalau.
अरे आगे को पर आओ क्या
ये बाय माना में जाने वाला इसको बना दिया लाउड देगा आएगा अच्छा देखो iya bang belum balik wala itu ikut ada deh gue dapat sih kan belum itu aku mau belum dapat ini sih ini kan ya lagi baru masuk माँ बेटा बात करेंगे But the banking is good now. But banking is good. Oh, that's keyboard play कर keyboard का
दे ओके साइड का क्लोज कर चिकना का ये बात है जो
अगर बुद्धि ने बोला कि ऐसा तो लगी तो मारने नहीं ये
मुझे sama मारने के लोग पीता है
ada ये ना देखो अंदर लेवल आगे देखा है मुझे नहीं बात आज गोवा में वेरी होंडे है इसका टिकट ये होंडे दिन बनाया बाबू काम करो ज़्यादा अम्बू
हाँ एक बार बोलते हैं पीता
आटो मचा बट बैग मुझे बैग ये तो ना वो नाता है तो ये आउटग्रेड में अगर जो मैं
ये मोटर ले ओके रिकॉर्डिंग को ना शान से
यार अभी तो अभी होगा अभी तो
सर मुझे देख नहीं सकते
आगे रहते ही बैठता
अच्छा
यही लग बात सही मुझे बा
थोड़े चातुर भी
ये क्या है लग रहा है कहते हैं ना सही हुआ
बिहार पिछली बार सब निकलो कि सीए को कुछ
पहले क्या यहाँ पे ये लगी हाँ पहले निकल इधर ये खाते हैं आपसे ही मानता
एक बार इसका पासवर्ड डाली ऐसा अरे मारता हूँ ना वही ना सर
चल गया क्या चल लाभ है
एक बार साहब वो एक बार सीख रहे तुम लोग कुछ लोग नहीं
तो ये
inbox මගේ කරන්න අඩේ මට අර වීඩියෝ එකේ වන්න කවුද
Right. Last week we have started the topic directors, and now we know that how to appoint directors, how to remove directors, what are the qualifications to be a director, what is the meaning of the term director, right? Minimum and maximum number of directors, like those things we have discussed. And also this side also we have discussed that we also discussed that there are different categories of directors, but in law the judges always refer to the board of directors, even though there is a different categories of directors in the business among the business people, right? So there is always look at the board of directors, whether you are executive, non-executive, independent, or whatever. The judge's view is that you are equally liable for the decision taken at the board. At the board meeting. Right. So we also have tried to discuss the powers of directors. Right? So now we know the by section 184 directors have given very wide powers, and then immediate next section, section 185, there is a very good restriction on wide powers of directors. What is section 185 is about? You have to you get a question from section 185, major transaction. Okay. So, section 184 says that yes, the directors have very wide powers. It says that business of a company and affairs of a company must be done by or under supervision of the board of directors. And then it says the board of directors have all the powers necessary for that purpose. Even though it says that the board of directors have very wide powers, then the next section 185 says, however, they can enter into the major transaction. Okay. To enter the major transaction, yes, law requires to be consent given by the majority of shareholders, not simple majority, but there's a requirement to pass a special resolution. That means more than 75% of shareholders must agree or pass a special resolution to enter into a major transaction. And then section 186 again says that directors can delegate their powers to a committee, a person, or any other person. Right? As an example, yes, if they want to delegate their powers to a committee, so example, you can say the nominee committee, audit committee, salary committee, right? So they have delegated their powers to some of those committees. And then, or director, someone like managing director can be appointed by the board, and can delegate some of their powers to a managing director or any other person, maybe secretary, maybe CEO, maybe finance director. So likewise, directors can appoint a person and delegate some of their powers. So at the very beginning, we knew that those employee, CEO, right? So according to the very beginning, that's what we have said about the definition of or interpretation of the director. Those type of people are known as the delegated directors. Okay. They are known as the delegated directors. However, the Act further says the powers mentioned in Schedule 6 cannot be delegated. Okay. Schedule 6 includes some of the very important rights of directors, like to decide the consideration, issue of shares, reduction of stated capital, right? Those type of things cannot be delegated to any other person or committee. They have to be done by the directors themselves. That is things we have discussed, so we have discussed from here to the directors' duties. Right. Directors' duties, we have discussed this. Right. So directors' duties Sri Lanka first time are now in written. They are codified in 2007. Until 2007, they were directors, they had duties, but they were decided according to the English common law. They were not written. Therefore, when a person wants to know what are the duties expected from a director, they have to look at the English judgment until 2007. But now they are written, they are capable, so very clear. Now it is certain. So what they have done is under the English common law, there were directors' duties, there are fiduciary duties, and the duty on skill and care. So those duties are now in written. Right? Right? However, there some section says, in addition to these duties mentioned in the Companies Act, English common law duties are still a part of Sri Lankan company. Therefore, this is one area where, even though we mainly deviate from the English law from 2007, in this area, still English common law is a part of the Sri Lankan company law. But we'll see now, I'm not going to discuss about those common law duties. We'll discuss the director's duties recognized by the Companies Act. So Companies Act, yes, from section 187, until 200, and again from section 219, 220. So there are some special duties, right? So we'll discuss those important duties starting from the section 187, right? So those all were common law duties at one time. Now they are written duties. Common law duties that you are clear. So this is answer. Then when I ask what are the director's duties, you can't blindly say that to attend the meeting and so, right? Because they are now written. Right? So this is the one main duty of the directors set out by section 187. Directors' duty to act in good faith. Sadbhavan Kartutina Yusuf. Very by they have a duty to act in good faith. Very by this right? Directors' duty to act in good faith. Right? So according to it says, a person exercising powers of performing duties as a director of a company shall act, right? Shall act in good faith and in what that person believed to be in the interest of the company. Right? Where he is a director. You can go through the section 187. One section all right? Again, yes. Shall act in good faith and in what that person believed to be in the interest of the company, where he is a director. Among director in a company, Sadbhavi, but what that person believed to be in the best interest of the company. Not what you think, not what I think, not what judges think. Judges are business governance with the a good care. So we believe, the law believes that the directors must be in a, they should have some good understanding about business. Ne? So they know their company, ne? They know business. Therefore, they should know what is good for their company. Therefore, they have to act in good faith, what they believe to be in the interest of the company. ඒගොල්ලෝ විශ්වාස කරනවා මේක අපේ කම්පැනි හොඳයි කියලා. අන්න ඒක තමයි කරන්නේ. වෙන මිනිස්සු හිතන දේවල් කරන්න ඕනේ. තමන් ඩිරෙක්ටර් කෙනෙක් වෙලා ඉන්න කම්පැනි අපතර මිනිස්සුන්ට කරලා බෑ තමයි. ඒක පොඩ්ඩක් කියවගන්නකෝ හරි වයින් දේවල් නේ. Director's duty to act in good faith. Good faith කියන්නේ හැම ඔඩිට් වලත් තියෙනවා ඔඩිට් වල ethics වල law වල සද්භාවයෙන් තමයි කටයුතු. මොකද සද්භාවයේ good faith කියලා වල තමයි අදහස් කරන්නේ. law වල හරියට යූස් කරනවා. bona fide mala fide නේ. bona fide කියන්නේ good faith. Mala fide කියන්නේ bad faith. ඊට ඉන්ෂුරන්ස් ලෝ වගේ මම කරලා පරිගණක කරනවා utmost good faith නේ. පොලිසක්. නේ. better utmost good faith. Very good faith. අපි දැන් හිතමු there is a two companies. A company is a holding company. B company is a subsidiary. So there are two companies, A company and B company. A company is a holding company. B company is a subsidiary company. So B is a fully owned subsidiary of A. B is a fully owned subsidiary of A. Now A appoints X as a director of B company to safeguard their interests. Right? Now in practice, X will act for the betterment of A company or B company. A company, right? Yes. Obviously, he will act for the betterment of the A company. As in it, right? Now, anything about again. They have to act in good faith for the betterment of the company, for the interest of the company. They are a director. હવે મેં વાગે આવતા કે કોઈ નજર હતા ને તમે પ્રોવિઝનલ કા ટેક્ટિક દીના right ટેક્ટિક મે પ્રોજેક્ટ દીના if there is a fully owned subsidiary of holding company then if the articles permit then this is the exception then such a director can act for the mother company or parent holding company even though he was a director of a B company he still can act for the betterment of A company but only if it is a fully owned company, right? 51%, 75%, you don't have it. That's an exception. Right. The good faith that the court will look at the reasonableness of the circumstances. Right? How an intelligent and honest person acts. Right? So an intelligent, honest person can come with that. Easy that right? Because it's a very subject to it. Like In this case, what happened was there was a company. I think we have discussed this under the share class, right? In this case, say A company want to take over B company. A company want to take over B company. So both want to get it done. Minority shareholders are also with the board of directors, but majority are against. Majority are against. Then they can pass a resolution to make a takeover bid a success. Then what directors did was they issued large number of shares to the minorities. Then they became majority. Then they pass a resolution. Then make a takeover bid a success. Right? Okay, come on, everybody. Capital society will talk that. Then, now minority, before the share issue majority filed a case. Right. They asked from the court to order that share issue was to cancel the share issue. Because it was void, the argument was that they have not acted in good faith. What do you think? There's a formal one may take for the take again. Kinsa. Hatal spark to cut the sugar, we suck with the head of Haruna. It was a resolution passed on by later. Who has the power authority to issue shares? Company shares issue can have the validity. It's a power of the board of directors. You have any kind of banning. You can stick to the directors. So it is within their powers. Right? What I found the other name was that done. And I'm Bali for Bali. If not, in law it is called ultra-highest name. We are the past name. The president emergency law passed on for one year. I'll get that. I'll put that in it. I'll get it. Emergency law passed over. So they have to use their power in a proper manner in good faith. Right? The person can pass an emergency law. Within the powers, betterment the president of the president partner. The some of the Huluan, to look in the cancer. This is a cat to know. Getting my president. So they don't just sit on my little. Now, president of Hulu right? They have used their power in good faith for the betterment of the society and country. Even though the board of directors have power to issue shares, that power is given to them to issue shares whenever they want to raise the capital. If they have issued shares to raise the capital, no one can carry it. And they cannot take the back. But in this case, judges was of the opinion that the board issued shares to dilute the voting powers, not to raise the capital. So they have used their power for improper purpose. Right? Share issue to raise the capital of the company. So therefore, court decided they have not acted in good faith. As a board, they have acted in good faith for the betterment of the company for all the shareholders. Therefore, court declared that the share issue was invalid. Kenisa Samaharata and Padlock the Gabanet now, Sadbaki. There's another case. In that case, it was doing some the company owned some cinema halls. Cinema hall Ekatuna. They knew that there was another hall was on sale. Now cinema hall then, however, the company had no money. Company then what they did was the directors pooled their money and they bought that company under their own name. ඒගොල්ලන්ගේ සල්ලි දාලා කම්පැනි අලුත් මූවි හෝල් එක දාන්න. But go to the company's team. Other than the director side, personal side. Then, as they expected, share value was increased. They will expect club again, they got the count. So, who will increase from again? Share value. Then these people sold their share because it was almost like more than that. Now, the company is under new management. They knew that what they have done, they have invested their money and then made the profit. Right? But then they filed a case against the former directors. What do you think? Nobody tell me. That without you know that. What more is it? In good faith, identify the recognize on all the case. It is obvious in this case, there was no loss to the company. Make a second, the company is part of the company is only got them. So good faith is not about the loss of profits. It is about the trust anchor. In good faith, trust confidence someone they have loss profit someone they are maybe. Right? So court decided they have not acted in good faith. Right? So therefore, court ordered that to return the profit they made back to the platform. Is that my position court some I think this could be another good case in that I think there's a deep try another like another June to go here, set the man. But the government was not acted in few men and a good faith on a way. Reckless negligence. They got reckless negligence of the like species of a candidate in the June. They go there, again. They to the so they were reckless negligence, make a someone and they get the term again. It's like right. The review again, then they it comparatively loud. Profit but the still court decided it is against the concept of good faith. So as the court, they have not acted in good faith. Right. Therefore, you have the board have to look at the company as parents. Parents are a company they have under board the game. Right. Take a father and another. Polga company, Kapala and another. Polga, Kala people not profit and go with that. Kapala and another, capital in Aslan. Right. So this is another duty expected from the directors. Duty to comply with the Companies Act and the articles. Right. Duty to comply with the Companies Act and the articles. As the directors of the company, they have a duty. They have no duty to act according to the wish of the shareholders. Right? As the directors, there's no law. There's no common law, statutory law, ethics, or whatever that they have to act according to the wish of the shareholders. Directors are appointed by the shareholders, but they are not bound to act according to the wish of the shareholders. But they have a duty to act according to the Companies Act and the articles. Same like that, the president or cabinet, they are not bound to act according to the our wish, but they are bound to act according to the constitution of the country. Right? Company, the board is bound to act according to the Companies Act and the articles of association. The director of a company should act or abuse the company acted in a manner that contravenes any person of this act or person contain the articles of the company. Right. A company was incorporated to sell shoes. The company's objective was is to sell shoes. The board of directors of this company decided to sell chocolate. What you can do? Company objective is to sell shoes. Directors of the company to sell chocolate. Well done. Then the bed, the bed. Company to chocolate figure on the bed. Object was again shoes, leather, right? Now directors decided to sell chocolate. You are an investor of this company, you have 10% shares. You are strongly against the chocolate business. The 40% paper. Diabetics. In the world, strongly against it. What you can do against the company? What you can do against the board? Or what are others? We have discussed all of them. So you have not regularly come and they are not giving your money. So you have 10% share, you are totally against the chocolate business. What you can do? Anyone? Anyone please? Well, Abdullah is like Musala. Katanya loke glass ke na kiya kata alu ani kakya kande no tam ko what you can do against the company? Company. Where's the object course? Object course se koi saman. Object course a part of the articles. Articles of association with the object course se appeal, ne? In an articles karga pol galo company. Karga company articles are pitching more. You can sue against the company under section 233 restraining orders. This is to the Velak we may have now against the company, not to enter into the chocolate business. Because we incorporate the company to sell shoes. Right? So now company act in contravention of the company's act, the articles of association. So you can sue against the company to restrain from the new business. Restraining order section 233. Right. However, section 233 says if the company has already completed the business, already started, then court will not order against the company. Because today's law is that company's business is not limited to the object law. Company can do anything. It's like I on the research not that. I business patanga the pass company on that. Patanga the pass. Then you can sue against the directors under section 188. What does it say? It says if the directors act in contravention of the company's articles, then they are breaking or breaching their duties. Right? So, object in articles, sir. Articles are shoes chocolate right? It is a breach of the articles. If the board, the directors act in breach of the articles, it's a breach of their duty because they have duty to comply with the company's act under articles. Okay. Yes, sir. Directors are common liable, right? So, in some object the directors are none of section 188 because it's their duty to act according to the Companies Act and the articles. Directors of major transaction resolution pass special resolution pass then but the 10%, 90% cash legal. In that special solution and pass then chocolate. Now what you get? The more 90% chemistry, chemistry, chocolate, trade and more than Thomas that 90% chemistry and you really can do that. Huh? So you believe that the majority is correct? That's not what I had to get into. Huh? No. There's no law that majority is correct. 10% different. But we also have to respect the majority. Majority respect the majority so you can exercise the minority buyout rights. Section 93 to 100. Minority buyout rights where you can request from the company to buy your shares for a market price. Section 93 again. Current 90% chemistry. Then you can request from the company to buy your shares as well. This company is bound to buy that share for a market price. Right? Section 93 minority buying price. Right? So this is another duty of directors. Directors' duty to comply with the Companies Act and the articles of association. This is another duty of directors. Directors' duty of standard of care. The duty of care and due diligence. This is also common law duty. Now it is written. So according to this section says, a person exercising powers of performing duties as a director of a company should not act in a manner which is reckless or grossly negligent. Therefore, if you are a board member, you cannot be reckless or negligent. Right? And directors should exercise the degree of skill and care that may be reasonably be expected of a person of his knowledge and experience. Samang in the top three, Kerenge, Balapur, skill and care, director Kerenge, Balapur, right? So therefore, they can be reckless, negligent, and they have to use their skill and care. If not, they are breaking their duties. So some countries now believe these are too much for the directors. As a result, countries like Singapore, New Zealand, very difficult to find directors. But that's not the idea. Everyone, like person, then what are just like I have a done. One low, I didn't done. Make it right? English, professional study, special burden of drama. Yes, that may be reasonably be expected of a person of his knowledge and experience. Then auditor can give you, auditor can give bar person. Lawyer can give bar person. Doctor can give you, doctor can give. Professions are very expected. Means that somehow after I had a mother director, so that it given it. So therefore, in some countries now it is relaxed to relax this second clause. Now what they say is if you were selected to the board because of your profession, then what is expected is from a professional of that profession. But even if you are an auditor, doctor, or whatever, you have not selected to the board because of your profession, then what law expect is what is expected from a general person, general lady. දැන් ඒ තත්ත්වය වෙනස් කරලා තියෙනවා. ඔයාලා ප්‍රොෆෙෂනල් කෙනෙක් වුණා බෝඩ් එකට ගන්න ප්‍රොෆෙෂනල් එකේ හින්දාලා අන්න ඒ ප්‍රොෆෙෂන් එකේ තියෙන ස්කිල් එක කියාගේ තියෙනවා. හැබැයි ඔඩිටර් කෙනෙක්. හැබැයි බෝඩ් එකට ගන්න ඔඩිටර් කෙනෙක් කියන්නේ. ඒත් අන්නේ පත් වෙලා ගන්න. එහෙනම් සාමාන්‍ය මිලිහෙකේ බලාපොරොත්තු වෙන දේ තමයි ඔයාලගේ බලාපොරොත්තු වෙන කියලා. දැන් ඒ තත්ත්වෙට පොඩ්ඩක් ඒක රිලැක්ස් කරලා දෙනවා. Otherwise, some people say it's too much to be real. Right. Accordingly, right? So, if you are a member of the board, right? So you can't. Yes, if you were not attend the board meeting, it may be a reckless negligent act, right? Or even you attend the board. Right? The director's duty is to attend the board meeting. If you are lucky, then that's bad. It's duty at the moment, but it is not such important duty, right? It comes under the duty of skill and care, not to be reckless and negligent. Right? Because even though you were present for all the board meetings, right? On a board meeting, but I have a board meeting, so has he complete his duty of skill and care? No, he didn't. හැමදාම බෝඩ් මීටින් 10ක් තියෙනවා 10ක්ම ගිහිල්ලා. වෙලාවකට කලින් යනවා නේ. රිෆ්‍රෙෂ්මන්ට් එක හොඳට කරලා ඊට පස්සේ කුටි ගන්න. දැන් ඩිරෙක්ටර් කෙනෙක් විදිහට යාගේ ඩියුටි එක කරලා තියෙනවද නැද්ද? No. Then this right to attend the board meeting just is not the duty of directors, right? Their duty is not to be reckless and negligent. ඒක තමයි duty එක, right? ඒකද බුලියන්නේ මොනවා හරි ගම yes කිව්වහම. So they do not do that, right? So they are not performing any of their duties. Duties not to be reckless or negligent. Right? So accordingly, directors cannot sign a blank check. Please trust Allah. Blank check it shows their reckless, negligent behavior. Right? So as the directors, they cannot be reckless or negligent. And also they have used their, but it doesn't mean that they have to keep their eye in 24 hours in the business, right? What is reasonably expected from a person of that kind? Samanamli balapotte. Can directors get advice or information from third parties or experts? Directors' duty about the use of information and advice. Can directors get advice or information from third parties? They can, because they are not expert in everything. Business forecasting. Right? Ela ඒක දෙනවා මෙලියලා දාන්න. පොඩ්ඩක් ඇඩ්‍රස් ගන්න ෆයිල් තෝ පාස් කරගන්න ඉන්න මට කියනවා ලීගල් ඔපිනියන් එකක් දෙන්න කියලා මට දෙන්න පාඩම් මාත්‍රා ලීගල් yeah good so subject what do you think? Can they be challenged? What is it? Can you get advice, information? Yeah, that's what director somebody or does something mind. So please careful about that. On the that there's no pending case scale. Lower side I see again lower side. But After the game and the very last of the other thing, so I need to be you have to go through that. Engine department. So I got engine department to take care of. Taking up time again. They have go through the document that was their department. Because in my opinion, there's no pending case against them. They were done because it depends rather than you. So I have plenty. But they can take advice and information. What about the thing that the advice you have taken, information you have taken? What is it? You got advice ke only take through them. By before making Baga Kalma, they are going to survey which will Baga. Yes. You can take advice or information because both are not expert in everything, but only according to the section 190. Right? Section 190 is right? The director of a company can rely on reports, statement of financial data and other information prepared or supplied and a professional or expert advice given by employee of the company, a professional advisor or expert, any other director or committee of the directors. Right? This should apply to a director if and only if the director acts in good faith. And first, they have to show that they have acted in good faith. And good faith again got the gap of Canada. Why is this making up to take up Colombo? Among right? You have to again, you have to take advice for information when it is necessary, but we have to act in good faith. And also makes a proper inquiry where the need for inquiry is indicated by the circumstances, right? There must be real necessary for such information. While they own a directors and has no knowledge that such finance is warranted, unwarranted. Right? Both the game Nata, done the Nata, now take Akta Shaka, they want good faith taking on the information done. Otherwise, just because of you take advice without any proper reason, then you can't justify it. Again, you are breaking the another duty. Duty to act in good faith. Therefore, they can rely on the information and advice provided that they have acted in good faith. Within the common law is still a part of the Sri Lankan kind of relating to the director's duties. Right? In this case, yes. Now, if you take advice information without a proper requirement, again you are breaking laws. Next, what about that? There is your company going to start a new business in the course, something like data, science law, or whatever. That none of the board members have no knowledge. If you can take it on that, the other business are but when you consult the firm, they also ask comparative type. Then you decided to go to the new business with your limited knowledge. It looks like you had no knowledge at all. As a result, compare the outcome. Suffer huge loss. What will happen? Is there any breach of duties? More than duty का breach करती है ना Almas Swedish advice gatto एक करता नहीं आवाज से information गाते रहता एक करता एक बाहर दे Again, 189, reckless and negligent. Right? If you take information advice without any proper reason, maybe amount to breach of director's duty to act in good faith. But on the other hand, whenever there is such a necessity, if you are not consult with proper person, it may amount to a breach of the duty of reckless and negligent. Right? It's a director says අවශ්‍ය වගන්නේ කයි. අවශ්‍ය වෙලාවෙ consult කරන එක දෙකම වෙනවා. So those are the main duties of directors. Duty to act in good faith, duty to comply with the Companies Act and the articles, and duty to be use their skill and care and not to reckless and negligent. So these are very wide duties, right? Apart from that, there are some other relevant provisions. So I say, we already know that the directors are different, companies different, shareholders are different. Therefore, there is no law that directors cannot do any business with the company. Right? Therefore, directors can also do business with the company. They can become a shareholder, supplier, creditor, right? They can act in any capacity. But if you say, if director make any transaction with the company, then they have a duty to disclose. They have a duty to disclose, and that transaction, that business shall be disclosed to the independent board of directors. They have a duty to disclose it to the independent board of directors. All of business are again disclosed. And yes, as the directors of a company, you do sometimes some information only available for the board of directors. Right? Maybe the some insider dealings, some information related to the insider dealing, or maybe current value, again, they were only available for the directors. Right? Therefore, in such a case, there's a duty that they cannot use the company information for the personal gain. Right? There's one case, IDC versus Kohli, right? Industrial Development Consultant versus Kohli. In this case, Kohli was a managing director of a consultancy firm company which provided consultation for the gas companies of that area. Right. Because of this man's personal skills, they had the huge demand. He was very popular. As a result, they charge this company the huge amount as well, comparatively maybe 4 times than the other company. In one company, they wanted the Kohli as a consultant of their company. Then they had a discussion. Then company has taken a discussion. Then the company requested a huge amount as a consultation. Kohli then may board the kina, Kohli one or Matam in the Mitra, Mungana, Evagi. They may disclose the details, then may have played board the game, make a consultant discuss the boarding. Following day, Kohli resigned from the job, and the following day, he was a consultant of the other country. Right? Then, this company where Kohli was a managing director, filed a case against the court for breach of director's duties. Right? Director's duties breach mainly what they argue was he has used the company information for the personal gain. Because it was available for the Kohli because he was a board meeting that discussed the consultancy. If he was not a board member, then that information was not available. Therefore, he has used that information for the personal gain. Then the company ordered him to prepay that amount that he charged from the company to the IDC company. Therefore, you can't use the company information for the personal gain. And also, yes, even the directors can buy shares because company is different, shareholders are different. They can buy shares, no issues at all, but they have a duty. What's the duty? To disclose all the transactions, right? They have to be written in the interest register. They have to mention the amount or number of shares they have bought and the consideration for the shares. So they have this duty to disclose. And also, yes, this one sometimes we discuss separately as well. However, I think we can discuss in the same case level the director's duty on insolvency and serious loss of capital. These are very unique duties of directors, right? So if you have a compare set of soft copy, just look at the section 219 and 220. Make a one calling me a serious section 219. Just try to read this section. Because no one will be happy to be director of a company if they know the seriousness of the director's duties. The bundle like just need to then you say to them, why? Medical bundle, serious. What law expect from the directors? Section 219, duty of directors on insolvency. This is also related to the winding up of a company. Company wind up count of this section in Tamara. Yes. How does this section start? One way of putting Anika. Found it. 219. The directors are in the key and the sections, right? When the mirrors are in Barack. When you file a binding up person, you can file a case against the directors under this section. The charter again, open book the Balalia and the Yet the Nene. Get Lakan Pai, I get it. Then you go make up the passport in the Pomalaga pass the money. Some will cut off. You know, just let me know that how does it start?
A director of a company who believes that the company is
That's what I want. A director of a company who believes that. A director of a company who believes that. They don't want to wait until auditor says so, independent person says so, whatever. Because directors are the business people. Right? Why they terms right? If a director of a company who believes that. Actually, Viswasa Karma, that the company cannot pay its debts as they fall due. You think? If a director who believes that the company cannot pay its debts as they fall due, then he has a duty to call a board meeting immediately. Director Viswasa Karma company bank insolvent if a company cannot pay its debts as they fall due, for this section, this insolvent. Samani, we are part of the compare. Now you want the back here, directly believe that. Right? I can't if he believes, then that director has a duty to call a board meeting immediately. And that meeting, board has to decide whether to continue, whether to wind up, or whether to appoint an administrator. Yes. And they can track that in. If they decided to continue, then those people who decide are liable. Right? So the second one is also the special duty. It is about the serious loss of capital. Here, serious loss means if there is a more than 50% loss of the capital of a company, then again there's a special duty on directors. Can you also read it for me, the first line? 220.
At any time, it appears to a director of a company.
Yes, right. If at any times it appears to a director, right? I did as a can do matter taking with matter may annual national. If at any times it appears to a director, director the old name without a penny and money. That the company is in the serious loss of capital, then the board has a duty to call each year. It has to be called within 20 days. Called within 20 days and to be held within 40 days. That was to take a if a director who it appears to director, if at any time it appears to director, that the company is in the serious loss of capital, then they should call a EGM. Come on, shareholders are in the Gera, or how many EGM? Then they have a duty to disclose the extent of the loss, the action they have taken, and then they have to make it open what they should do next. Right. So those are my special directors. You can see the director's duties, right? Apart from those things, the director disclosure, all those things, director's duty to act in good faith, not to be reckless, negligent. If it appears, if a director believes that, right? You know, they are very wide. Right? There's a huge responsibility to be a director of a company. Right? So, unfortunately, anyway, in Sri Lanka, even though first time the director's duties are catalogued, still there are no very proper provisions. How should they punish if they violate these sanctions? It is missing. Right? As an example, in England, now there's another law, director's liability act. A good faith character spend 10 years interest. Right? Punishment right? But then we can do is the court will punish sometimes, or the shareholders can remove it. They can expect from the directorate. Punishment clearly mentioned. Right? So therefore, still our people are lucky. Directors are still lucky. So probably the Directors Liability Act will also, yes, it will be so marked by the Parliament. That case, they have to be more serious and careful. That direct make a case here, but they will be expelled from the director. Then someone no one at fault. Just bad luck. One of them gave us comparing at the means to boil with the Vetamano, other Vetamano, maybe Vetamano, no one at fault. Bad luck, but probably they are reckless, negligent act of directors. Comparing to Makata than bad, directors are finally attacked, no one take a mate. Fire fault at the foreign great matter. You are reckless, negligent act. Second. So I have no idea to discuss the corporate governance in detail. Yes. People I don't know about the corporate governance. Why corporate governance is important when we discuss about the directors? The corporate governance is a system, right? It's not directors' duties, right? Corporate governance is not limited to the directors or board of directors. It is a system. It's a system which the companies are directed and controlled in a due manner. It can make companies the system, due manner system. Directors for the corporate governance, it not only includes the directors, it includes auditors as well, secretaries as well, managers as well, CEOs as well. Corporate governance directors are right? A corporate governance auditors, secretaries are also definitely part of the corporate governance. A corporate governance so corporate governance ensures that those who are responsible for the governance of the company would properly govern it. Director's duties is It's the main thing, right? Directors' duties are main thing, but corporate governance is a subject for you. It's subject as well. Finally, I think. Yes. Because now it has become a subject in many disciplines. Because now corporations are like government. Even government, so many companies, they have a turnover which is more than the GDP of a country. Look at it, lots of Lanka GDP. It's a huge money there. And also, they are influenced. Some other companies are influenced, huge number. And also, they act in all over the world. And they interfere the business, not only the business, to interfere business is their job, part of their job, but sometimes they interfere the unethical things as in the politics of the country, the sports, the religion. So those are the things done by some corporates. So it's like government, right? So therefore, you have to make sure that they direct and control their business in due manner. The new subject is evolved as a corporate governance. So for this corporate governance, it's not limited to the directors, but definitely directors have a main part. Maybe corporate governance the directors are mainly in secretaries, auditors, managers, CEOs, corporate governance part. The main thing is the corporate governance is basically it is subject to the codes, or maybe some codes or whatever prepared by the private organization. There's nothing passed by the Parliament of the country. Corporate governance is a good governance code, best practice code. Even corporate governance, right? So they are prepared by the private or some semi-government organization. They are not laws. Therefore, even if the company does not comply with those codes, there's no method to punish them. Right? Organization codes corporate governance, right? So, therefore, even though the company breach or break those codes, still there's no method to punish them. That is not the CSC rules follow still you can't punish, but you can delist them. Delist them now punishment. Then that is why directors' duties are important. Directors' duties are part of the companies. It is a law passed by the Parliament. If they breach or break, then there are punishments. Right? Therefore, directors' duties are main part of the corporate governance. That's the only law that the directors can be punished. Other institutions have enacted codes and best practices. Practice is standard to ensure that the companies are properly governed, right? So they are not same legal effect as the companies are. Companies that are law passed by the Parliament. If breach or broken, there are punishments. Best practice code Carter CSC rules please try. So those are some of the codes related to corporate governance. Code of best practice. This is qualified by the Chartered Institute. Code of best practice on audit committees. Code of best practice on corporate governance. Lanka keep up the Hamilton CA Samadhi. Makitan CA Kata Arutako Kodia Haran Velatina internship. Tarantula made us a real sit per internship. Video get a bit memorable. Tackle 9 times then real sit right. So they are completely against the law, right? I have repeatedly described in my tasks. Right? Work of Buddha, cutting up with the prison name is a one out of the higher tasks like this is not ethical, this is not legal. Right? අපි කිව්වල ගණන් ගන්න නේද? ඉන්න කියනවා ටයි එකක් දාන්න. නැත්නම් පිළිගන්නේ නේද? right. So ඒක clearly against the labor laws, right? 8-hour working, 8-hour is a right, it's not a privilege. ඒක right එකක්. නේද? මේකේ වෙන්නේ ළමයි 24 hours නේ අපේ ළමයි කැම්පස් එකේ ඉන්න කෙල්ලවල සාධාරණ උදේ 5ට යන්නේ රෑ 8ට ලෙක්චර් එකට නේ. අපෙනුත් දරුණා අනෙනුත් දරුණා නේ. house station ගියාම 24 hours කරලා නේ. ඉවරනේ 7000 8000 දැන් නම් 50ක් කියනවා මම ඉතින්. ඒක හරිම අන්දේක නේ ඒක දවසක පරිදි නේ. I mean you are not immigrant after doctor entitlement දුන්නේ බා for the expenses නේ. ඒක මට හිතාගන්න බෑ ඒ වගේ professional organization එකක් ඒ වගේ steps එකක් ඇයි ගත්තේ නැද්ද කියලා because they need to know the basic labor laws. ඒකව කියන්නේ මේකට වැඩ කරන ප්‍රම වෙලාවක් අයත් යනවා. ඔක අවුරුදු 3ක් ඉස්සර 4ක් ලම. කරන එක තමයි අවුරුදු දෙකකින් කරනවා 4 හිටියත් 8 හිටියත් බැරි කාක බෑ. අපි වෙන එක නෑ. අපිට ඉතිරිය කියලා මොනවද කියලා නේද? මම යන 2 years more than enough. 2 years ඇති. ඒ නිසා මේ නේද? බුදු වෙන්න කිව්වා කියලා. බුදුහාම බුදු වෙනකන් තව මාසයක් පාදේ ඉන්නේ. right? ඔය කවුන්ට් කරන අවුරුදු 7 දැන් සුණානේ. සුණානේ. දැන් ඉස්සරහට මේ හතරක් කොහොමද ඉතින් බලන්න විකාරයෙන් අලුවගේ කාලෙන්නේ මේ කියන ටෙක්නොලොජි එක්ක දැන් මිනිස්සු මේ 4 year degree කියලා සිනාම කාලයක් ඇවිල්ලා ඉතින් මේ වගේ කාලෙක AI සමාන ඉලක්කනේ කාලෙක අවුරුදු 4ක් ඔක ප්‍රැක්ටිස් කරනවා කියන එක මම I don't know why these people don't read නේ එහෙමයි එහෙනම් ඉතින් උඹලා ගොන් හරක් වෙන්න අවුරුදු 4ක් ගිහිල්ලා නේද? ඔව් ඒලා ඉතින් නේද? අවුරුදු 7ක් කියන අවුරුදු 7ක් ඒවා ගිහලා නේද? ඒ කියන්නේ ප්‍රැක්ටිස් එකෙන් හරියනවා වෙනවා. So it is a high time for them to read it, not because of any other thing. It is illegal, it is in the especially the young boys and girls. The young men you have to enjoy your life. The account sector, Ganaka, Indonesia, ඒක හරි මම නැතිව මම හිතන්නේ මේක definitely very eye opening instance. සාමාන්‍ය මිනිස්සු පිළිගන්නේ නැහැ නේද? So මේක හරිම eye opening instance එකක් වෙයි. Definitely they have to read it. Right. ඉතින් මේ චුට්ටුවල ගන්න support එකක් right. මම කියන්නේ හැබැයි ඒව වුණාට මේ ඔක්කොම ethics හදන්නේ උන් තමයි නෝ. ඔක්කොම ලංකාවේ ගොඩක් මේ corporate governance සම්බන්ධය අරගෙන either it's done by the CA or they are participating. But they don't just like directors. Directors are so they are to protect, safeguard, develop someone else's property for themselves, not for the directors. Shareholders are doing ඒගොල්ලන් දේවල් ගන්නව බාර කරවයි දෙයක් දැන් directors කියන්නේ. But practice for them, shareholders comes last. Practice to get the shareholders of the one, until they go to it or creditors or bank for some. Directors again, allowances in a concern. Now, make shareholders again. They will protect and they go to come up until one sarcasm. Right? Right. So, there are some mandatory code of corporate governance from 2008. So now these are mandated, right? These are mandated because we are on corporate on a PLC especially listed companies. That inclusion of non-executive directors need to make disclosures, criteria for independence, and need to have the remuneration committee and audit committee. They are now compulsory for the PLC. Accordingly, every PLC should have independent directors. Every company should have independent directors, either 2 members, so 1/3, whichever the higher. Now it's almost like a law, mandatory requirement. In listed companies, 2 directors, so 1/3 of directors must consist of the independent directors. Take a law, right? It's enforced through the SEC Act. Right. Then, in the annual return, they have to disclose how do they decide the independence. Independence director කෙනෙක් කියන්නේ එක කියලා දෙනවා කොහොමද independent වෙන්නේ කියන එක ලෝකේ කියන්නේ right. So the each company can decide it. So they have to disclose it through their annual return. ගොඩක් කරාට කියන්නේ ඒගොල්ලෝ shareholders not independent වෙන්නේ නැහැ. Non shareholders තමයි independent director වෙන්න ඕන කියලා. But there are few companies they have decided if they have less than 5% shares, still they can be independent. හැබැයි shares විතරක් නෙවෙයි නේද? Relations side now. So anyway, they have to disclose it to their annual how do they decide the independence in their companies? Take a decide here. Apart from that, salary committee and audit committee and nominee committee only consist of the independent directors here. They can vary independent directors against again. Right. So those are something. This is I just mentioned about the corporate governance. Corporate is a separate subject for you, right? Right. Okay. Then have a break. The past papers are given a lesson there. Answer why Mangula pass like a head
The office is the pass credit.
Well, the law is Monday. The pass. I can't touch it. And someone papers in Banana made us a paper for retire and the Saman. We think
Already You are the person.
Right. Then we'll go to the second part of our lesson. Now we have just fixed the directors. The first part, their appointment, qualification, interpretation, and secondly, we have discussed their duties of director. Now we will discuss about the secretaries and auditors. Secretaries and auditors. For the secretaries, we can discuss within 10-15 times. 15 times, 15 minutes is more than enough because in the Companies Act, there's only 2-3 sections about the secretaries. So we discuss these appointment of secretaries, their qualification and their role, change in role and their powers. So do you do the internship as well? Yes. Have you ever seen the company secretaries? Men? Yes. Yes. What's their role? Are they all ladies? Right. So, notice that every company, same like directors, every company should have a secretary, and to incorporate the company, there must be a company secretary. And also, law says that if a company is a PLC, sorry, if a company is a limited company or subsidiary of limited company, or even if a private limited company, if its turnover is more than 1 million or stated capital is more than 500,000, then such companies have to have a qualified secretary. So, if a company's turnover is more than 1 million or stated capital is more than 500,000, such companies have to have a qualified secretary. Qualification is not in the Companies Act. The act is to be described later by special gazette notification. Company secretary's qualification are now being prescribed by special gazette. So you can compare them with the qualification of the secretaries with the qualification of directors. To be a director, if they are properly appointed directors, they have to sign a Form 18. That means directors need to get their written consent to act as a director, so as secretaries. Secretaries also have to give their written consent to act as secretary of the company. For the directors, it is Form 18. For the secretaries, it is Form 19. It is also one-page document. What do you think about the director's role? Well, I secretary बोल कर सामान. बोलो बाहर के बारे दिया है ना. Let's go to the qualification of directors first. Who can be a director? Whether foreigner can be a director of Sri Lankan company or not. Whether foreigner can be a director of Sri Lankan company. Foreigner can director. Yes. Whether foreigner, non-citizen or non-Sri Lankan can act as a director of Sri Lankan company. Yes, there's no issues. This could be even a foreigner can act as a director of a company. Even they can be shareholders, but there's a special method, right? They have come to be and all. But to act as a director, there's no issue. The foreigner can act as a director. Whether a foreigner can act as a secretary. Secretary of the who it is? Director secretary in the banner. Islam DNA. Secretary should be a citizen of Sri Lanka and be ordinary resident in reside in Sri Lanka. So secretaries, only Sri Lankan citizens can act as a company secretary. And they have to normally reside in Sri Lanka. Samani Lanka will Sri Lanka secretary. Directors are no issues. Any person can be a director. And then we discussed in detail that there's no formal academic or professional qualification required to act as a director. But it is different from a secretary's role. You can see when it comes to secretary, there are, for the qualified secretary, there are list of qualifications. So only attorney at law, member of CA, member of Institute of Chartered Secretaries and Administrators Sri Lanka, member of SIMA, can only act as a secretary of the company or assistant secretary, they will say another previous act. Right? So you can see they have some proper academic and professional background. They only can act as a secretary of a company. Right. Now, in some countries, for a private limited company, any person can act as a secretary. Even in Sri Lanka, if turnover is less than 1 million or stated capital less than 500,000, any person can act as an auditor or secretary in such a company. But obviously, in that sense, there cannot be any company with more less than 1 million turnover. Unlike in that sense, almost all the companies should have a qualified secretary. However, before 1971, at the very beginning of company law, there were no such list of qualifications. At the time, in England, any person could act as a company secretary. And also, it was clearly believed that company secretary is a person like a clerk or servant. That was traditionally they believed. Secretary should do what board or directors ask him to do, then he has to do it. He's similar to a role of a secretary or servant. But this was questioned in this landmark case. I think you have discussed it for the agency law and some other topics as well. Panorama Development versus Fidelis Fellowship Fabrics Limited. This case was decided in 1971. This is the case that changed the role of company secretaries. In that case, what happened was the company secretary hired some expensive luxury cars purported on behalf of the company, but in fact, they were used by the secretary and his family members. As the rent was not paid for 5 months, car rental company filed a case against the company. They were very expensive cars, all were Benzes and Rolls Royce. Then the car rental company filed a case against the company for the rent. Then in that case, company argued that they were rented by the secretary. We have not authorized our secretary to enter into the agreement with the car companies to rent out cars. And he has no such authority as well. Therefore, we won't pay. You have to get them from the secretary person. Then this is the case. The question was, who was liable to pay the car rental? The secretary or company? You can think of two angles, either company law or agency law. What do you think? Company's argument was, company secretary has no such a power. He is like a servant or employee. He is there to do what board him to ask to do, and nothing else. That was the argument by the company. That was the law. But by 1969, Companies Act has introduced different sections, especially some qualification to act as secretary. But more than making, how the given donor, other than taking to company given donor, secretary given donor, more than Isla company law like that one secretary connector, you know that. Secretary connector role in the Nika mere clerk connector, servant connector. Oh, they did, even at some point, duck. It does not fire. Nick can get a wife for your nation. That cut your bike on in India. Amalo in India. What is it? Secretary to Evage agreement tag done, Pruvan Kereta, the aggressor. Low Amatar මොකද secretary කියලා නිකන් මීන ක්ලාක් කෙනෙක් කියලා හිතනවද ඔයාලා නැද්ද? එහෙම හිතන්නේ නැහැ නේ. right. සාමාන්‍යයෙන් බෝඩ් එකක් වුණත් ඩිරෙක්ටර් කෙනෙක් වුණත් තව ගන්න ටක් දාලා එයාගේ තමයි ඇඩ්වයිස් එකක් ගන්න හදනකොට ස්පෙෂලි ලීගල් ඇඩ්වයිස් නේ. ට්‍රේඩින් බිස්නස් ඒවා ගන්න නැතුව. right. ලීගල් එකක් ආවොත් ඩිරෙක්ටර් කෙනෙක් වුණත් ටක් දාලා ගන්න ගොඩක් වෙලාවට ලීගල් ඔෆිසර්ස් නැත්තම් කෙලිම දාන්නේ secretary තමයි දාන්නේ නේ. එයාගෙන් අහන් තමයි දාන්නේ. right. And this is also evident by the qualification list. When you look at the qualification, I don't think you can describe the company secretary as a mere clerk or chartered accountant or FIMA member or lowest line. එහෙම කෙනෙක් මේ mere clerk කෙනෙක් කියලා කියන්න බෑ. ඉස්සර එහෙම ප්‍රශ්නයක් තිබුණා. ඉස්සර ඕනේ ගෙට පුළුවන් නේද? දැන් එහෙම කියන්න බෑ. Therefore, in this case, court decided role of company secretary has been changed. It is evident by the Companies Act by their qualification, and also at the end of the section Companies Act, there's an interpretation section 529. It interprets the term officer. It says officer include director, manager, and secretary. So company secretary is also considered as a company officer. That's what by secretary, right? So they are considered as company officers. And therefore, court decided company secretary is not a mere clerk or servant anymore. He is a administrative officer of the company. Today, even they act as a advisors to the board. They take board meetings, they advise board, all administrative contract and administrative part of the company or business are run by the company secretaries. Therefore, court was on the opinion that company secretary is a chief administrative officer of the company. Therefore, he has the right to enter into the administrative contract here. So this is administrative contract. Therefore, he has such the right in the company was land. Therefore, company has to. So you can also think of this case according to the agency. Agency law pattern. If company is a principal, secretary is the agent, the only requirement is that the secretary should have authority to act as an agent. Authority is one half. That authority may be either actual authority or ostensible authority. If third parties can reasonably believe that this person has the authority, then the company was liable. Make express treatment authority because there were no such law that company can enter into contract, but court decided any reasonable person can believe that the company secretary has the ostensible authority or implied authority to act on behalf of the company relating to the administrative contract. If we have the authority, whether it is implied or ostensible, then the principal is liable. යාගේ රෝල් එක ගත්තාම යාගේ ක්වොලිෆිකේෂන් ගත්තාම යාගේ හැසිරීම ගත්තාම ඒගොල්ලෝ ඩිරෙක්ටර්ස් අත් එක්ක තියෙන සම්බන්ධය ගත්තාම right. So third parties can believe that he has the authority to enter the contract on behalf of the company. Therefore, the company was liable. Right? Therefore, in that case, the role of company secretary was completely changed. Now, no one believes that company secretary is the mere clerk or servant, is the chief administrative officer. Therefore, definitely he can enter into the administrative contract. Apart from that, in the Companies Act, right, if any person requires the company document as a true copy or authorized copies, right, there are many occasions you will see, even though they are signed by the directors, some organizations will not accept. But if they are signed by the secretary as a true copy, then they will accept. Right. Basically, almost all the authorized documents of the company are signed or authorized or signed as a true copy by the company secretary, and any organization, including the government organization, will accept it. Right. Sane api oppuwa liyanne kiya api kiyanne me resolution එක pass කරන secretary කියනවා. සමහර ඩිරෙක්ටර්ස් අස්සම් කරගත්ත එතරම් ගහලෝක අස්සම් කරලා යන්නේ. හැබැයි සෙක්‍රටරි කෙනෙක් එක කරන්නේ ඒක හදලා මිනිට් කරලා ඒ වගේ දාන නම්බර් එකක් දාන දෙන්නේ නේ. Then yes, we ask the certified copy certified by the company secretary. Right? So therefore, you can say he or she as a clerk or servant. And also, when there is a share certificate are issued by the private company or limited company. Listed company, they don't issue share certificate. But limited company or private limited company issue share certificate. So share certificates are also issued by with the signature of the director and the secretary. So anyone will accept it as a certificate of ownership. So they are basically signed by the secretary and director. And also, if there is a company, it is not must. If there is one, basically company is also under the authority of the company secretary. And also, all the dealings with the company and registrar of companies are also done through the company secretary. That's the main role of the company secretary. And apart from that, all other communication with the other authorities and the company are also represented by the company secretary. Therefore, some people really misunderstand that the role of the company secretary is to incorporate a company, right? Incorporation can be done by any person. You all can do it. Company can incorporate nothing. ඒක පැය භාගයක් වෙලා ඕන කෙනෙක්ට කරන්න පුළුවන්, right? ඒසා company secretary කෙනෙක්ම incorporate කරගෙන නෙවෙයි minutes තියාගන්න එක, register හදන එක, share register, index register, interest register, to pass resolution, to keep minutes. So, those are the acts and duties and authorities of the company secretary. Right? But unfortunately, Sri Lanka, I think the majority of the private companies, they don't know the role. And if you go to many private companies, they don't have any of those registers because they don't have a company secretary. And even if they have company secretaries, they are also not qualified or they are not familiar with the company secretarial works. So that is why many organizations, the proper organizations, proper companies are happy to buy company secretaries. They are members of the Institute of Chartered Secretaries and Administrators in Sri Lanka. They have a huge demand to act as a company secretary, even more than the CA members and the attorneys. ඒගොල්ලෝ ඒකම හුළු වෙන කට්ටියක්. ලංකාවේ හොඳම කම්පැනි සෙක්‍රටරි සහාය ගන්න තැනින් තමයි. ලෝයර්ස්ලා හැමෝම කිව්වනේ හැමෝම ක්වොලිෆයිඩ් ඒකට අපි හැමෝම ඕන එකක් පිළිගන්නවා නේද? කවදාත් ක්‍රිමිනල් කේස් එකක් කරනවත් ආවොත් බාර ගන්න. එහෙමනේ. ඒ වගේ ඕන කෙනෙක් කම්පැනි සෙක්‍රටරි කෙනෙක් වෙනවා. නමුත් ඒක හරියටම කරන්නේ නැහැ. අරගොල්ලෝ එහෙම නෙවෙයි තමයි. That's one of the very proper institution. Similar to chartered management normal ඒ වගේ එකක් තමයි. නමුත් ඒගොල්ලෝ the 2-year course, they only train the people to be a secretary of the company. So they are a very proper person and very popular person recruited by the professional organization as a company secretary. Right. So it is a company secretary, right? So secretary generally do not involve in the day-to-day business of the company. But definitely, even secretary can call a meeting. She does it on advice of the board. Well, board meeting at the most secretary on behalf of the board of directors. Right. The main role of the company secretary is to among others, is to pass a resolution. Because we all know that the company is a fiction. We all know that the company is a fiction. Therefore, on behalf of the company, someone has to sign the document. Right? Who can sign the document on behalf of the company? Section 19. If the immovable property, 2 directors. Or 1 with the written consent. If it is not the immovable property, then they can be signed by any person who has a express or implied authority. But the question is whether those people have authority. This one is person able to authority. Directors are the next assignment made in a director. Especially this is the issue with the banks. Mortgage loan and Gama. Able common and directors can sign anything. But how do you know that they are directors? Kalindas do not resign when to put one. Some people traditionally ask for a Form 1. But Form 1 says about the initial directors. Form 1 initial directors like they go down the directors of all remove the resignment. Then some people ask about the Form 15, that's an annual return. Right. Someone Form 15 annual return, but that also includes the details about the date of annual return. It updates Form 1 have a annual return. Then when you enter the contract with the company, how do you know that those people who sign have the authority? Make sure that I mean assign directors maybe directors like here. Maybe the balance if you are pretty sure there's no issues, other than the non-person. Even the COVID, then I mean, Asanka, may compare with an Asanka full of 15, 15, 5,000. Either possible, Form 15 will be a director. Then what one compare to one, well, I was one of the So 15 on the antenna, but they can come latest. Updating have a pilot and doesn't. Take a master that had done by the master that had it on the a director are not take another. When it over a sample. And for homes and plans are on here, or the director side for the person that is Thomas Santa. But I just said it to something. Just like for other name. But that is one type of plan. They have a first person. You are both together like girl to a first person to awesome. So among all that, then we have a monkey that is awesome. The name of Santa or authority. Follow that. Yes, but the company can deal with the bankers. So when we're going to go, then not under 90%. Someone in the company, some other more. The best way to, yes, solve this issue is to get the copy of a resolution. But this one, Yojana someone copy of that. Right? That is why resolutions are very important, right? That resolution must say that the company has decided to buy this land, if it's a land, or to enter into this transaction. Then it must say further company resolved to appoint these two persons or to authorize these two persons to sign the transfer deed or any other related document. And this transaction company has decided to do so and so. Then there must be another paragraph that the company also appointed to authorize these two persons, so any two directors, so and so, to sign the relevant document. And then it is good to have another sentence that is not against the Articles of Association. So this is within the Articles of Association of the company. Right? If you have a resolution with those three, then those people definitely have authority. There's no issues at all. Resolution. It is also good to get that resolution with the signature of the secretary. ඔන්නන්ගේ නම තියෙන දෙන්නගේ ඊට පස්සේ identity card එක ඒවා cross check කරනවා. That's the best way to deal with the companies, right? Company can be represented by anyone. This doesn't matter. It may be even implied. But if you don't know, if you have a resolution, there's a crystal clear. Right. Inside resolution has changed the mode. Take a work out. Command deal alone. Okay, your second assignment is when you come next week, draft a resolution. Right? You can do it as a pair. Right? Then make a answer. Right? As resolution is passed. Right? It's a one-page document. Right? So, pass the resolution that you are comparing. You can decide anything, but if you have nothing in your mind, you pass a resolution by your company that the company has decided to buy a land. Company has decided to buy a land. So then the company need to, yes, appoint or authorize 2 persons for that transaction. So draft a very nice, proper resolution that is required by the other party to sell this land. So I want it next week. It's not a big deal, okay? Do it as a pair. Sorry? I can understand. Comment resolution again. Right. So anyway, yes. So if you don't have any other special idea, draft a resolution to buy a land. But if you have any other special things like to get a lease agreement, to get a building, or to start a new business, whatever, you can do it as you wish, right? Right. We can go to the next topic as well. Auditors. The easy auditors are available. Auditors are available. By the way, auditors are Lanka with the Peter don't like those that net we get our looking back and away. Lanka and net never in the valley. Anyway, definitely it's not a traditional auditors anymore. Traditional auditors are in the Galle year. Now thinking IT low tech auditors like this. Traditional auditors may debit credit other auditors are located on nether. Among in the Galle. Now they are naturally hit on the home IT really over. Lanka and Ghana, they are one of the cases among Australia, Mama, a family, a cake of IT people. I was about 2 years ago. Apela, my wife to be hitting my yard, common, I was a minor. He can make that to my IT problem. Make it. Santa have a Lanka, have a made IT the Michael. Lanka, have become IT. Lanka got down campus got down. Engineering faculty, IT, computer science, software engineering team. You have a campus technology faculty. Technology faculty was IT. It was a hammer faculty, computer faculty. It is common computer. It was a science faculty, computer, art faculty, computer. It was a management faculty, the business analyst, Mankitan make a husband reasonable take over mega function. Then may article and in one hand, it's good. It's all about skill in a country. Now, may I the one that job less take a 10 take a dinner IT. Take an IT to Mankitan, IT, I make up that one. We'll make it up to the These are the subtopics that we will learn. Right? Auditors के सामान्य in law faculty, so law college we don't teach, but as this is a separate gathering management faculty, we take the similar weights as directors for the public auditors as well. Right? So, if I ask you to describe or use a one word to define auditor, which one will you use? What law expert form you go whatever? Auditor gets someone especially what law expert from an auditor. The majority already go into it, right? Have you seen the audit report? Audit report they have some kind of someone. What are some kind? Someone so make a name of the what the use the what? But still you can. That's smart. Well, auditors are give one of the experts. Because the expert can take a down in the food drinking. Yes. Yes. You are under the take care. I can't get what no expert for man? Yes, I'm done with that. So, what's the history of their name, Amitan? Yes. I really like your answer, right? Audit report that you are independent audit report. So that's exactly what independence, right? Auditors are independent means, right? Yes. Other business they don't require auditors, so for partnership, there are auditors, but it's not a legal requirement. But for the company, it's a legal requirement because company is owned by the shareholders, run by the directors. The owners don't know what they do. Therefore, to fill that gap, there must be an auditors. But if they are not independent, if they are also with the directors, then there's no issue, no use. They must be an independent thing, right? So independence here, we discuss next week. Almost all the sessions of the compliance are there to protect the independence of the auditors. However, it is not that easy to maintain it. Here, not wrong, when I'm not wrong. Practice කරන ගියාම ඔය කියන දේ වෙන්නේ right ඒ හින්දා වෙන්නේ නැති මම හිතන්නේ central points එකේ audit කෙනෙක්ට මම හිතන්නේ gas acid ගහවද ලහිර වගේ එකයි so that would be the end of independence ඒක හරිම වේදනාකාරී වැඩක් කියලා කියන්නේ acid ගහන එක නේ ඒ නිසා මේවා උගන්වන සාන් ලේසි නෑ කරන්න ගියාම මම හිතන්නේ හරි ප්‍රසිද්ධයි ඉන්ඩිපෙන්ඩන්ට් ඔයිට කෙනෙක් කියලා අන්තිමට ඇස් දෙක අදලා පාස් right ඒක ඉන්ඩිපෙන්ඩන්ට් වෙදිකල් සෙට් නේ police දෙකක් කරන්න ගියාම වර්ක් මම කියලා තේරුණා ඉන්ඩිපෙන්ඩන්ට් දෙක it may end up using in that this Don't apply experimental figure. After very nice. It is the group of but at least you need to know workflow expense properly. So now I can tell you, working the next. Good luck, put it not the actual, but something. Audit money, the consultants. That is completely outside there now. Okay, anyway, so we'll see then the next week. So we can yes, finish the auditors next week, and probably we can also start the wiring companies. Then come in the resolution as soon as. Okay then. Those who are not in the country, they can send they can leave the email. Okay, that's see you.
Thank you.
Please consider possibility to get part of the answer.
Johnny.
Instead them